Today's lecture centers on a cornerstone of modern international law, human rights law. We will trace its historical development, explore its core principles and instruments, and examine the challenges it faces in the 21st century. The evolution of human rights law. The concept of human rights is deeply rooted in history, with various cultures and philosophies recognizing the inherent dignity and worth of every individual. However, the formalization of human rights as a branch of international law emerged in the aftermath of World War II. The atrocities committed during the war highlighted the urgent need to protect fundamental rights and freedom. The Universal Declaration of Human Rights, UDHR, adopted by the United Nations General Assembly in 1948, marked a watershed moment. It set forth a comprehensive list of civil, political, economic, social, and cultural rights that all individuals are entitled to, regardless of their nationality, race, religion, or other status. The UDHR, while not legally binding, served as a blueprint for subsequent human rights treaties, including the International Covenant on Civil and Political Rights, also called ICCPR, the International Covenant on Economic, Social, and Cultural Rights, or ICESCR, the Convention on the Elimination of All Forms of Discrimination Against Women, or CEDAW, the Convention on the Rights of the Child, CRC, the Convention Against Torture and Other Cruel, Inhuman, or Degrading Treatment or Punishment, CAT. These treaties, along with regional human rights instruments, form the backbone of international human rights law. Core principles of human rights law. Human rights law is based on several key principles. Universality. Human rights are inherent to all human beings regardless of their background or circumstances. They apply equally to everyone, everywhere. Inalienability. Human rights cannot be taken away or denied except in specific situations and according to due process of law. Interdependence and indivisibility. All human rights are interconnected and equally important. The realization of one right often depends on the realization of others. Equality and non-discrimination. Everyone is entitled to the same rights and freedoms without discrimination of any kind. Enforcement and protection of human rights. The enforcement and protection of human rights rely on a multi-layered system. Domestic implementation. States have the primary responsibility to implement human rights through their domestic laws and policies. International monitoring. UN bodies and treaty-based committees monitor state compliance with human rights obligations. Regional systems. Regional human rights courts and commissions provide additional avenues for redress. Non-governmental organizations, or NGOs. NGOs play a crucial role in monitoring, advocating for, and protecting human rights. Challenges in human rights law. Despite significant progress, human rights law faces ongoing challenges. Cultural relativism. The debate over whether human rights are universal or relative to cultural values continues. State sovereignty. Some states resist international scrutiny and interference in their domestic human rights practices. Non-state actors. Non-state actors such as armed groups and corporations increasingly pose threats to human rights. Implementation gap. The gap between the recognition of human rights in law and their realization in practice remains a major concern. The future of human rights law. As the world grapples with new challenges such as climate change, inequality, and technological advancements, human rights law must evolve to address these issues. This involves strengthening international cooperation, enhancing accountability mechanisms, and empowering individuals and communities to claim their rights.